Today, we're taking a closer look at the DOJ's continuing prosecution of law-abiding gun dealers, MAGA sheriffs, and the machine gun law letters at the center of it all. I'm Phil, and you're watching Law and Ammo. But before I get into the video, I want to take a second to tell you guys about GOA's annual convention. Goals. The Gun Owners Advocacy and Leadership Summit is set to be held August 9th through 10th of this year in Knoxville, Tennessee. Come out and visit with some of your favorite manufacturers, participate in activism training, and hear from some of the top voices in the Second Amendment community. And the best part is that it's free for GOA members. So sign up today using the link in the description. And now back to the video. Everyone knows that machine guns are unfortunately strictly regulated under federal law. For an ordinary person to legally purchase one, they need to pay the Bureau of Alcohol, Tobacco, and Firearms and Explosives a $200 tax, register the weapon, and pass a background check. But they also need to shell out north of $10,000 to buy the weapon itself, if not tens of thousands of dollars, depending on the model. That's because since 1986, a provision of the Firearm Owners Protection Act, known as the Hughes Amendment, has prohibited the private ownership of new machine guns that are manufactured or imported after that date. The Hughes Amendment is codified at 18 U.S.C. 922-0. And its artificially created scarcity has caused prices of pre-1986 transferable machine guns to skyrocket, whereas a lower receiver for an AR-15 might cost as little as $50. A virtually identical transferable M16 lower receiver can cost upwards of $30,000 or $40,000, or maybe even more. And of course, as is always the case, the government exempted itself from its own gun control scheme. Thus, Congress established a way for licensed gun dealers to sell new post-1986 machine guns to state and federal agencies. That's where law letters come in. The Hughes Amendment provided that the 1986 ban on machine guns does not apply to a transfer to or by or possession by or under the authority of any department, agency, or political subdivision of government. And another provision of federal law, 18 U.S.C. 925A1, reads similarly, saying that the Gun Control Act's provisions shall not apply with respect to firearms imported for, sold, or shipped to, or issued for the use of the government. That's pretty broad language. And for decades, the ATF has interpreted these statutes to impose only minimal requirements. Licensed gun dealers must also seek a law letter or demo letter from a sheriff or local police chief, stating that his department is potentially interested in purchasing new machine guns, or merely in seeing one demonstrated. And armed with that letter, ATF would then approve the transfer of the new machine gun to the dealer. Then, if the agency decides to place an order for those machine guns or ask to test or demonstrate some, it would then be able to do so through the dealer. Under this relatively simple process, new post-1986 machine guns owned by gun dealers are often called post-86 dealer samples. So soon after the Hughes Amendment passed banning new machine guns, ATF issued a regulation explaining how this law letter requirement would work. This regulation basically says that transfers of new machine guns to licensed dealers will be approved if it is established by specific information the expected governmental customers who would require a demonstration of the weapon, information as to the availability of the machine gun to fulfill subsequent orders, and letters from governmental entities expressing a need for a particular model or interest in seeing a demonstration of a particular weapon. And very importantly, ATF's regulation only ever required that agency law letters express a need or interest in a new machine gun before it would approve a transfer to a dealer. ATF never required proof that the new machine guns were actually demonstrated to the government agency, that the agency actually placed an order, or that the machine guns were only used for official duties. And that makes some obvious sense. Sometimes agencies change their minds. maybe after budget cuts, changed priorities, needs, whatever, and decide not to follow through with any new purchases. Or agencies might simply want to see certain machine guns demonstrated, but only to train officers on how to recognize or disable different types of weapons in the field. And even if an agency does purchase a dealer's machine guns, the statute doesn't restrict what it can do with them. So for example, some local sheriffs hold machine gun chutes that are open to the public. As one federal judge recently noted, even the FBI does this. Relying on the ATF's long-standing approval of law letters, post-1986 machine guns have proliferated, with hundreds of thousands of them now on the Federal Registry. And anyone who obtains certain firearms licenses may import, manufacture, or otherwise obtain machine guns, sell them to agencies, and transfer any unsold machine guns amongst themselves. But all of that changed under Joe Biden and his anti-gun handlers, like ATF's Eric Epstein, who was not happy about all the lawful machine guns circulating within the firearm industry. And so suddenly and without notice, ATF changed course from its long-standing practice, and the DOJ started criminally charging gun dealers and the local sheriffs who had issued them law letters under a novel legal theory. So for the first time ever, ATF claimed that a local law enforcement officer's possession of new machine guns must be within the scope of his or her official duties. But the statute only requires that a machine gun be possessed by or under the authority of a local sheriff. Nothing about use for official duties. And even so, if the ATF claimed that if an agency's later use of a machine gun deviated from the ATF's newly made up standard of official duties, then the DOJ would consider such possession to be unlawful, and also charge those involved with making false statements in the associated law letters. DOJ would even throw in conspiracy charges just for good measure. ATF also claimed that firearm dealers could not possess post-86 machine guns unless they were actually demonstrated and actually sold to police agencies. Again, that's totally different than ATF's regulation, which requires only a need or interest on the front end. But none of the ATF's Biden-era law letter requirements can be found in the statute, or even the regulation ATF itself had issued. Instead, these prosecutions were politically motivated, plain and simple. Just another example of DOJ and ATF's weaponization against law-abiding citizens and gun owners. But there's even more here, because most of the Biden DOJ's targets in the law letters cases were vocal supporters of President Trump. More than one were outspoken MAGA advocates. In other words, ATF's law letter prosecutions involve members of local law enforcement who resist federal overreach, law-abiding gun dealers who facilitate the Second Amendment supply chain, and ardent supporters of President Trump. That's hardly a coincidence. Instead, ATF's law letters prosecutions represent a deliberate effort by the weaponized Biden-era law enforcement and radicalized Biden-era DOJ officials to persecute the left's political opponents. And unfortunately, Biden's persecution of gun owners already has claimed some victims. The Biden DOJ's test case was Bradley Wendt, a licensed gun dealer who also served as the chief of police for the small town of Adair, Iowa. Charged with making false statements in law letters under ATF's new theory, Chief Wendt was convicted at a criminal trial presided over by a Biden-appointed judge. But Chief Wendt has since appealed his conviction to the 8th Circuit, where GOA filed an amicus brief in his support. During a recent oral argument in the appeal, 2 of the 3 judges saw right through the DOJ's theory.
Is this inherent in his position as the police chief, or is it the result of some delegation? You know, because if you look at the statute itself, it says that you have to possess it under the authority of a political subdivision. There's a political subdivision of the state.
It says by or under the authority of the subdivision. And I actually think that by is a pretty good argument too, but under the authority of, I think, has to be a slam dunk. Because yes, he was using it for other purposes, but as I've already mentioned, the FBI does it regularly. Every 6 months they do this. I'm sure I've heard stories of the marshals doing it. I mean, this is what happens. And so I don't know that we want to start going down this road.
And so it looks like the Eighth Circuit is very skeptical of what was ATF's first prosecution of a police officer for possessing a machine gun. And that's not the only black eye Biden's ATF received on its law letters debacle. The Biden DOJ's second law letter prosecution was of Robert Kropp, a licensed dealer, and Chuck Jenkins, the Trump-supporting MAGA sheriff of Frederick County, Maryland. Unfortunately, this one didn't work out for the Biden administration. Even within deep blue Maryland, a jury unanimously rejected ATF's made-up standard, voting to acquit Kropp on all counts. Biden's DOJ then quietly dismissed the remaining charges against Sheriff Jenkins. As it turns out, the Trump administration inherited one final law letter prosecution from the Biden administration, and it's still ongoing. This case, also in Maryland, originally named 5 defendants, one of whom you will be familiar with. That's because this is the Larry Vickers case. Larry Vickers is a decorated U.S. Army Delta Force veteran, popular firearms reviewer and YouTuber, and the owner of Vickers Tactical. He was also a vocal critic of gun control and the Biden administration. The Biden DOJ charged Vickers, as well as Maryland gun dealer Sean Sullivan, New Mexico gun dealer James Tafoya, Coates, North Carolina Police Chief Matthew Hall, and Ray, North Dakota Police Chief James Sawyer with engaging in a criminal conspiracy to acquire post-1986 machine guns on the very same law letters that ATF once approved. ATF also named as an unindicted co-conspirator Manny Gonzalez, the former sheriff of Bernalillo County, New Mexico, a Democrat turned MAGA Republican and another ardent supporter of President Trump. And so rather than face trial on these charges, Larry Vickers took a plea deal in late 2023. Police Chief Matthew Hall followed suit just last year, leaving 3 defendants with cases still pending. It doesn't make any sense why Attorney General Pam Bondi's controlled DOJ would continue pursuing these Biden-era criminal charges, or why this Republican-controlled Congress should even fund it. Since taking office, President Trump and Attorney General Bondi have been historic defenders of the Second Amendment. From establishing DOJ's first ever Second Amendment Enforcement Task Force, to pursuing anti-gun jurisdictions for violating the Constitution, to rolling back regulations and cleaning house at ATF. We are confident that this Biden-era political persecution simply slipped through the cracks. We hope that Attorney General Bondi and the DOJ will review the charges in this case and see these prosecutions for what they really are: a politically motivated persecution of the Biden administration's political opponents, brought by a previously weaponized ATF and FBI. DOJ and the U.S. Attorney in Maryland should do the right thing and see to it that the charges against Sean Sullivan, James Tafoya, and Chief James Sawyer are dismissed. This would not be a defeat for the DOJ, but instead a victory for gun owners against the former Biden administration. It's more important now than ever that gun owners keep up the pressure. Call your representative, write to them, engage with them on social media, and tell them that continued funding of these sorts of political persecutions is simply unacceptable.